Welcome to your iconic image. If you want to take control of your image and be a power player in your space, then this is the show for you. Here we will arm you with tools and information to help you grow your brand on purpose. I'm your host, Marlana Semenza, photographer and visual strategist. Now let's dive into today's episode. Randi Karpinia transforms entrepreneurs' ideas and inventions into intellectual property assets that can lead to huge profits. With over 20 years of legal experience, she is a recognized expert in all aspects of business legal management with a focus on intellectual property rights and management. Welcome, Randi.
Thank you. Thank you for having me.
So first, let's just ask, what is intellectual property?
That's a great question. And many people it sounds very legalish, right? Like, oh, that's not for me. But intellectual property is your intangible assets as a business owner. So the easy answer is there's kind of four categories: patents for inventions, copyrights for content and literary, trademarks for brands, and trade secrets for the things you just want to keep to yourself. And many business owners are so busy just working on the market, they're developing those things. They're developing their brand, they're developing their content, even developing patentable ideas, and they just don't realize, because intellectual property sounds something for big corporations, but in reality, it's something that should be in all of our business plans.
So the last one was interesting to me, that it can be trade secrets. Give me a for instance.
Oh, yes, the one that us lawyers like to use all the time. I'm sorry about
That's okay.
Of course, that happens in a podcast. The one everyone always likes to use as an example, because we all know it, is the Coca-Cola formula.
Okay.
Right? Coca-Cola's been around forever. That company, as many, thousands, hundreds of thousands of employees it's had over the years, has managed to keep the actual formula a trade secret. So they never protected it. They protected it using a trade secret. And the way you do that is legally very, very detailed. It's almost like putting a safe in and locking it up. There's some very important procedures that need to be put in place, but sometimes that is the right thing to do.
Interesting. So let's say, because it never occurred to me that things like, would somebody, like, let's say an Emeril Lagasse, who has his spice blends or something like that, can that also fall into that category?
Absolutely, absolutely, because you can't patent recipes. It's almost impossible. You can copyright them, but people can change one thing and it's done. So yeah, but what's important is if he's giving each, say, head chef in each restaurant the formula, it's no longer a trade secret. So they would have to be processes. Like, I don't want to misspeak, but for example, I believe when I've researched like Coca-Cola, so this would be the kind of things he would have to do. No one would have the full recipe.
Got it. So he could provide them, let's say, with the spice blend in a container.
Yes.
But not the recipe to create.
And then just a very few need to know have that. Yes.
So at what point does something become not a trade secret? How many people would have to know?
And that's the hard part. I actually don't recommend. I know we've gotten off talking about trade secrets. I don't normally recommend. It's an interesting area because the law is pages and pages, and then there's federal trade secret laws. There's state trade secret laws. Each country is different.
Oh, wow.
Most entrepreneurs, smaller businesses, big corporations can do it, but most smaller businesses wouldn't have. It would be very difficult and time consuming to really keep it a trade secret. And if someone copied it and then they want to enforce, it gets more difficult, right? Whereas if you have a trademark on your brand, if you have a copyright on your content, a patent on your invention, you take that piece of paper and say, you're infringing.
So now that you brought up copyrights, let's talk about those, because it's something that as a photographer I'm familiar with. So let's say because I was always under the impression that once something is created, it is copyrighted. Is that the case? And what does registering it with the Copyright Office gain us?
Absolutely. And as a photographer, and I've seen your work, some of your work, I'm sure that this is something you have all the processes and you work with all the time. So you are absolutely right. And many people don't know that. So I'm glad you said that. Copyright law, unlike any other intellectual property ownership, occurs for the originator immediately upon creation. So if you take a photo, unless you're doing a work for hire, and I won't go into all that, but if you are taking a photo, or if somebody is creating a business, let's say a training course, a lot of people are doing training courses now, that material is automatically the copyright is owned by the originator. The problem is to enforce. So it's great. I own the copyright, right? When this video is finished, this podcast is finished, you own the copyright to it. That's great. But if you don't want somebody to copy it or you want to enforce, you need to register. So what does that mean? Okay, maybe I don't register the copyright because I have so much content, but now somebody's copied me and and it's blatant, and I'm willing to put in the financials to stop them. I want to put a stop to it. Then you need to register. Now, where the benefit of registering early versus when you find out about an infringement, which was your question, if you are registered and somebody copies, there are statutory damages. Each and every instance of the copying, plus attorney's fees, legal fees. If they have been copying and you hadn't registered, and then you go after them, you file the registration and then you sue them or you demand, you have to prove actual damages. You have to prove that 10 customers that would have paid you $1,000 each, whatever it is, for that content went to the other person. It's very, very difficult to prove actual damages. And then you don't get lawyers' fees, attorney fees either.
Okay. So let's say with a photograph, I can produce a raw file or something like that to kind of prove that I created it in the first place. But let's say you have a song or you have, like you said, a training course. How do you, maybe it's easier with a training course, but how do you prove that you are the originator with some of these other contents?
So there's no proof needed unless we start talking litigation. Okay, so when you register, and this goes for copyrights, trademarks, patents, you basically raise your hand or your attorney if they're filing for you and say, I swear that I am the owner. There are no other claimants in copyright terms. They call them claimants. And that so you're telling the government that you are being truthful. Now, so what happens is there are laws. And if you commit fraud on one of these offices, it can be as much as jail time. The penalties are pretty high. So it's sort of like when you get on the stand and you see on TV, they get on the stand, they raise their hand and say, yes, I'll tell the truth. That's exactly what you're doing when you're registering a copyright, trademark, patent. You're telling the government that, yes, I am it. And they trust you until someone says differently.
I was just going to say, because what if somebody else comes along, like, let's say, I use a song because it seems that in the recesses of my brain, this has occurred, where somebody says, I created this piece of music or this song, and somebody else comes along and says, no, that's mine.
Mm-hmm.
So how does one prove that, or how does that become?
Yeah, that becomes litigation.
Okay.
And it becomes very expensive. Again, we're talking about copyrights. Just to move, I could keep paralleling the others since the questions are great. In the trademark world, the trademark office actually, during the process of registering a trademark, has a period of time called the opposition period. It's a 30-day period when the trademark has been allowed. The examiner says, yeah, I'm going to give you this trademark. And anybody can file what's called an opposition. I always tell my clients it's a baby litigation because it happens in the Trademark Trial and Appeal Board, where someone can say, no, this, if you get that registration, it's going to hurt me because either one, I have something similar, or two, I've been using it, I just didn't register it. And it happens all the time. And even that, I said litigation is hundreds of thousands of dollars. Even TTAB proceedings, if they go, they're definitely like a baby litigation, and they can, run anywhere from, if you settle 25,000 up to, so the costs just really skyrocket. So it's in your best interest to only register what's yours. Unfortunately, there's many people out there, both validly, like someone may have just happened to come up with a similar song, maybe not exactly the same, the tune kind of sounds the same, or, a brand name. Very likely someone in California and someone in New York could come up with the same name and be using it. So it's something that you have to look at as I'll call it an IP owner on both sides. Protect yourself, have the proof of when you created it. Always have the proof somewhere, and then just make sure that what you're using, you're not copying. And that happens a lot. I have a lot of clients who come to me and say, I've developed this content, and oh my gosh, I'll just make it up. Tony Robbins has this great, thing that he says, and I can't say it any better, and I'm going to use it, and I can't. Be creative. I always say, try to use your own, because it's the other side. We're trying to protect what we do, but we also want to keep from, getting a demand letter, being sued for infringement ourselves.
So let's say we go to trademark something, and you said that there's a period where somebody can come forward and say that, no, I've been using that or whatever. Let's say I went to register a trademark, but you've been using something. How would you know that I've tried to trademark it?
Yeah, so there's something called a clearance. And, I don't want to be mean, but it's a little bit interesting. I won't say funny, but it's interesting for me when, say, a new business owner or someone who's just developed a new program and they've come up, it's very emotional. When you come up with a name or a brand, it's really emotional. It means something to you. My firm name, Sagacity Legal, means something to me, even though you would be like, what? Who cares, right? And when I do a clearance, if the business owner isn't yet using it and they come to me ahead of time, I always recommend a clearance. And, we can do a short one, or we could do, very worldwide. I'm doing one right now worldwide for a client, to try to find out what is the chance of getting that registration. And there are times where I say to the business owner, yeah, I don't think you should use it because of this or because of multiple. And it's hard for them, because then they have to go back and think of something else. And it happens all the time. But before you get out there, before you're, a lot of people come to me for a trademark after they're getting big, right? Oh, now I see this is, I need to protect this. The problem then is if there is somebody out there, they could have to rebrand late. And we can all rebrand, but it's better to, upfront.
So what's the difference between a trademark and a copyright?
Yeah, people get that confused a lot. I get people coming, I have this name, I want to copyright it. No, you want to trademark it. So let's go through the three, right? So trademarks are for names, phrases, logos. They are things that identify your brand. So if you have, say, a phrase that you just happen to use in your messaging, but it's not branded, it's just something you say, that would not be trademarkable. But if you have that same phrase and it's at the top of your website, and it's the name of your courses, and you use it, in a very distinct branding way, and you, of course, know all about branding, that would be a trademark. So just having a name, phrase, or logo isn't enough. It has to be identifying your brand.
Okay.
Copyright is for anything in a tangible medium. So it used to be, we'd say books, we'd say written materials. Well, now it's video, audio, anything in a tangible medium you can do. Now the key with copyright is you're protecting exactly what I call it, deposit. So there's different names. In the trademark office, it's a specimen. In the copyright office, it's the deposit. It's really just your proof. In the case of the copyright, so if you, say you pretend this was a training video and you said, Randi, can we copyright it? And a year from now, you make some changes. You have to copyright it again. So the registration is specific to exactly what you do.
Right. I know even with images, when I have registered them with the Copyright Office, it has to be that exact title, and there can be no variation.
Exactly. So yeah, you have that experience. Copyrights are easier to register in that there's not this major examination to see if there's something out there confusingly similar. That's what the trademark office would use. The patent office would use. They're all, there's a lot more examination to trademarks and patents, but the value of a copyright is the exact thing that you deposit.
Okay. And so then what's a patent?
So a patent is there's two kinds of patents. One, let's kind of flow in from trademarks and copyrights, is called a design patent. That is for an ornamental look and feel of a product. Now I say a product, but graphic user interfaces go in there, icons. So that's where it overlaps with trademarks, right? You could trademark an icon as a brand, but you could also trademark a graphic user interface as a design. So that's one kind of patent that again, they all kind of overlap a little bit. The patents we're used to talking about are what are called utility patents. And these are new and novel, useful functionality.
Okay, and what does that mean?
So that means that you came up with either a product or a software. I do a lot of software patents in our digital world that doesn't exist anywhere. And you say, wow, that's really hard. How could that possibly be? Like the US alone, we're in the 11 millions in the patents. But I just yesterday mailed a ribbon copy of a patent to a client. I mean, that's where you work with, people like me and my firm and others like us who know. And so again, with patents, so I'm kind of flowing the process. It's a lot like trademarks, and we always look and see what's out there first. We do a patent search and a legal opinion, and we say, oh, you developed this product, this little niche piece, this is new, let's get it, so it's complicated, but I have first-time inventors. I love it. I have moms who came up with things because they're just because. I can't talk about what I have right now that are moms who came up with inventions simply to make their life better with their babies, and patentable inventions. During COVID, it was funny because when COVID hit, a lot of my colleagues at other law firms were talking about, things kind of, people aren't going to come get a lawyer when they're worried about all these other things going on, or they're not in the office or whatever. My business exploded in that, like right after March 2020, because people, just everyday people, were coming up with ways to deal with the pandemic. Everything from, I can't talk about the inventions, but things that allowed them to do their function or their service in person while keeping the other people safe, and things like that. And so there were a lot of first-time inventors that came out of COVID.
Interesting. And it seems like if you have something, the best bet is just to go to an attorney like you and say, this is what I have. How do I protect it? Because you'll be able to point them in the correct direction.
Absolutely. And just like with trademarks, if you come to me, I'm not going to, I've actually had this debate with other law firms. Bigger law firms will say, okay, here, I'll write your patent for you. I actually take a different approach in that I want to first see what's out there. So I will, anyone who comes to me, the first thing I'm going to say is, let's see what exists. If it already exists, we're not going to patent it. And you need to know that, because if you develop the product, you don't want to be infringing, right? It's always those two sides of the equation of you want to protect it, but you also don't want to step on someone else's IP because it can be painful.
Right. And I know that you offer a free IP consultation. Is that correct?
I do. Many of my clients, whether they're big corporations, bigger companies, or, brand new startups, they really don't, we started the conversation with what is intellectual property. So I found that, no one's very few people, unless they're referred and unless they're knowledgeable. Like if you wanted someone to do your copyrights for you just because you don't want to do it yourself anymore, you know the process. So you might not need you'll say, okay, fine, let's get to work. But most people need hand-holding. They need explanations like we were talking about today. So I do a lot of education, and yes, and I make it really easy for people to have a free consultation with me, because they just go to meetwithrandi.com. You can't get any easier than that, and they can schedule. And with most of my clients, if not all, our relationship grows over time. So at first it might be the business name and the brand, and then it might be the content. And then in the process of developing the content, there's something patentable. And then there's a new brand, so it's a longer term relationship, whether it's with my firm or another IP firm. It's sort of like your accountant, your marketing, might have a fractional marketing person you're working with, having an IP attorney looking over your shoulder that you can kind of call and just say, hey, should I do something with this? That's kind of how I've set up my own firm.
And I feel like this is an aspect of business that many people overlook.
Yeah. I kind of have two sets of clients, right? I have clients who are going to watch this and get on my calendar and start early. Or they'll watch, just to give other things. I have a YouTube channel where I post a lot of videos. It's attorney Randi Karpinia. Really, I make everything really easy. And so I'm constantly trying to educate so people will know. But then the other clients I have are those who come to me so stressed, so upset, don't know where to turn, because either they've been copied or they've received a letter from a law firm that they're infringing, and they don't understand. What did I do wrong? And even when I send infringement letters, most of the business owners are shocked. The people that I'm sending them to for my client, they're like, what do you mean? I thought, I just liked the name, so I used it. So just as a business owner has a business plan, a financial plan, a marketing plan, there should be an IP plan in place.
Does copyright infringement always turn into a legal issue as far as somebody suing somebody? I guess what I'm really getting at is, let's say somebody uses an image of mine, because unfortunately people on the internet think that everything on the internet is usable because it's there.
Yes, and I'm constantly posting and doing videos on it. It's just because it's there, it's not free to use.
Right. So let's say someone uses an image of mine and I find out about it. And you send a letter to them. As long as they, let's say, cease and desist from using it, perhaps I drop it. At what point would you recommend us not dropping it?
So the problem is, litigation is stressful, and
Mm-hmm.
it's
Yeah.
always value versus budget versus risk on everything I do, right? So in
Mm-hmm.
your case, and I've done, I don't like this part of my job, like, because I'm not a litigator, by the way. I'll just say that right out. If you need litigation, don't come to me because I won't do it. I just out. I don't like um, arguments and all of that. So what happens most times, not always, because it becomes a decision, is exactly what you said. The law firm sends a cease and desist, explains what they've done wrong. They've broken the law. They've infringed. They've taken your photo and used it all over Facebook, or maybe in one post. That's still infringement. And I've had clients who've received cease and desist because of a personal post they wrote on Facebook. So, by the way, I'm going to put one of my tips that I tell everybody is go through your LinkedIn, Facebook, Instagram, whatever you got. And if you don't know where that content came from, just delete it. Go all the way back, however many years, because infringement can be enforced from the time that the owner knows about it.
Mm.
So it could be. Last year I had one that was 3 years ago, and that was literally a photo that somebody posted on a Facebook business page. So what normally happens, I want to say, at least in the cases that I deal with, is the owner, for example, if it was one of your photos, you don't want to add that burden of litigation, but you also want to protect your rights and you want it. So normally there'll be a demand to take it down immediately, of course, all of the legal things. And most time a settlement is offered. Now, the settlement, if people go, oh, that's not good, then I can just copy everybody's stuff. No, because the settlements run, $10,000, $15,000 at times. It's not, it's not pennies. So, and then we negotiate. So because of those two pieces, the fact that you have to take it down immediately, but then you also will have to negotiate a settlement of some sort to compensate the owner for what you did. It could be little, could be, $500, or it could be, $20,000. Then it'll go away, right? Then it becomes, and there's even something called a settlement agreement that you could sign. But in some cases, and I have those clients as well, the cease and desist gets sent and the person keeps infringing. They just ignore it. And then they start to work with, infringement, IP infringement litigation firms. And that's very, very expensive. And unfortunately, if you don't know, up front, if you're going to, it's not like a personal injury where you're paying a percentage. You're putting out the money for the law firm. If you win and you've registered prior, you'll get that money back, but you don't know that for, years sometimes.
Interesting. What about in cases like, let's say on YouTube, where there's a share button and people share that content?
Yeah, so share's a little different, right? And that's all over the web. And I'm going to talk not only about YouTube, but all over the web. Someone might share an article, a blog post, a YouTube video. In those cases, the owner, if they've offered, like on YouTube, the owner is allowing that sharing. If you look, most website terms and conditions, so not just YouTube, but like I have websites, blogs, allow for the sharing, and in the terms say yes, you can share a link, but you cannot copy and paste it, right? So, but I have seen websites and arenas where the terms do not allow for linking, right? It's totally up to the owner.
Right.
So you can't presume that you can share a link. In the case that you gave, like YouTube or LinkedIn or any, that's kind of embedded into the terms, but it's not a necessary in all websites.
Interesting. So the bottom line is if you didn't create it and you can't prove it, you don't own it, don't use it.
You got that. You said that better than I can say it. And yes, absolutely. What I always say is it's better to do your own original B+ work than risk being sued by an A+ creator.
Love that. Okay, Randi. One more really quick question. Well, hopefully it's a really quick question. Let's say you create something for a course, or let's say you have an idea for a television show, any of these kinds of things. And okay, let's take the course. You create all this documentation for this course, and you have a training pamphlet. Can somebody take the ideas out of the pamphlet and use them, or what is copyrighted? Is it the pamphlet in its entirety, or is it all of the pieces of that pamphlet?
That's a great question. And I've had numerous clients who come to me like that and say, the way I do it and the transformation I provide in my service is so, I want to protect this. And I say, well, we can't, it's people-based, so we can't patent it. What I've done, so it gets a little strategic. This is where you need to like really sit down and delve into it. But some of the things I've done is we will copyright a process flow that leads to the transformation along with all of the materials, so that then we own that flow. And you mentioned TV. I've done it numerous times, even this year, for people. They have an idea for a TV series that they're going to pitch to the big channels. We will not only copyright the pitch deck, but the flow of the series, so that try to protect the concepts. It's not foolproof, but it's a good way. That's a great question because it comes up a lot.
Yeah, because it was always my understanding that you cannot copyright an idea.
Correct.
But you're saying that
copyright has to be in a tangible medium. Okay. So if you took that idea, if it was a flow, you created a flow chart, we do step, and it might be, if you're talking about a course, that may be the modules of the course. We do this, then we do this. And by the way, at the end, this happens. And then you just hope for the best. Yeah.
Okay. And with that, because you gave us a lot of really great insight and information. And once again, if anyone has a business, if anyone has anything that you are producing or selling or any of those kinds of things, I strongly suggest you reach out to Randi or somebody like Randi, because you really need to delve into that aspect of what you are doing. Absolutely. And make sure that you're protected. So with that, Randi, I just have 4 final questions for you.
Sure.
The first one is, what's the best piece of advice you were ever given?
Yeah, and this is a little bit of a personal story, and you can, for those on video, they can see. So I was cleaning out some things, cleaning out a lot of just clutter back about 4 years ago, and getting my business off the ground right around the same time. And the universe handed me this. I have no idea where it came from. Well, I know who said it, but I don't know where this piece of paper came from. It's handwritten, and it's on the back of, you'll see it's like on the back of this thing. And it says, if you don't build your dreams, someone will hire you to help build theirs. And it just smacked me in the face, because it's so true for me and so many people I work with. I was a paycheck person for a long time, and now I'm like totally an entrepreneur, and I work with entrepreneurs. But that's like the best piece of advice. And I forgot who it's quoted from, someone.
So then share with us one thing on your bucket list.
I have a big thing on my bucket list. I'm planning and working towards it, which is I want to live in a condo with floor to ceiling windows on the ocean, because I want the ability to look out. Water is very important to me, and I want the ability to be able to just stare out at the vastness of the ocean.
Love it. When the toy companies finally get around to making an action figure of you, what 2 accessories will it come with?
Okay, well, one is very easy. There will be a stack of patent certificates, of copyright certificates, of trademark registrations, because to me, that's my superpower. Whenever one of my clients gets a patent, or actually a couple of weeks ago, I got a patent. But whenever one of my clients gets a patent or a trademark or a copyright, they're so excited, and it's so. I just want, I think the doll would have all these certificates, and they're very pretty, by the way. The government does a good job. And the second is totally away from business, but it tells you a little bit about me, and that's my Fitbit. So I've become, as I get older, I've become very interested in holistic life, not just my business and helping people, but my health and my sleep and what I eat. And so I'm not like crazy about it, but I like numbers. And so I'm constantly looking at, okay, did I exercise today? Okay, what are my numbers for the day? So my Fitbit is my friend.
Love it. And the last one, how do people find you?
Yeah, I've said a few. If you want to talk to me, meetwithrandi.com, get on my calendar, we'll chat. If you just want to learn more about this thing called IP, I have a great YouTube channel that I'm constantly adding content to, and it's Attorney Randi Karpinia, really easy. My website, I have a blog, so there's information about our services, as well as, again, a searchable blog where you can look up different topics, and that's Sagacity Legal, my firm's name.com. And then I'm on LinkedIn and I'm on Facebook. So either of those are a great place to just connect.
Love it. Thank you so much for all of your insight, Randi, and thanks for being here.
Thank you.
Thank you for joining us. Once again, I'm Marlana Semenza, photographer and visual strategist. Please comment, like, or share this episode, and don't forget to subscribe so you don't miss a thing. For more information on how I can help you create your iconic image, visit marlanasemenza.com.